So are the other commissioners in the room?
They are listed.
Yeah,
Okay.
I'm here.
All right. Okay, so we can start. All right, let me start with, I guess, taking appearances from everybody first. That'd be first order of business. So,
Hi, good morning, Mr. Chairman. This is Bob Weissar, McNeil Wallace on behalf of water companies.
okay.
Mr. Chairman, good morning.
Good morning.
Wait.
Go ahead. Go ahead, Mr. Crooks.
Good morning. This is Ed Crooks with the water companies as well, sir.
I understand. So,
Good morning, commissioners. This is Jennifer Purvis appearing on behalf of staff, and I believe that Lloyd Spivak will be joining me. And we have Dave Valcarengi with me and Barbara Weber also.
Good morning, Chair Hoover and Commissioners. Brock Miller on behalf of OPC, and I'm joined by Lafayette Morgan, regulatory analyst who worked with us on this case.
okay. Okay, so that's all the parties. So let me explain kind of how we got here. My understanding is that the water companies filed for a rate increase, and that eventually led to a settlement agreement between the staff, OPC, and the water companies that was filed with the public utility law judge. But she, in turn, made a change in the settlement agreement going from a 2-year phase-in to a 4-year phase-in. And that caused the water companies to petition an appeal of the public utility law judge's orders. So in reviewing the issues in this, I guess we were struck by the fairly significant rate increases that were being proposed as part of the settlement agreement, both under the 2-year plan and the 4-year plan. And I guess what I would like to get today is maybe an explanation of sort of how we got here. I mean, it appears that the company hadn't filed for a rate increase for a number of years, and that's a little concerning to me. The other issue is they apparently got some advice from our staff as to how to proceed. So I would like to have a full explanation of sort of what we got, how we got here, and then maybe some ideas about how we get from here. That includes offering the parties a chance to take another crack at trying to come up with a settlement that maybe fixes the problem. Or if you think that's a exercise in futility, just given with the facts of this case, then we can set a procedural schedule for some evidentiary hearings in this case, and in which case we'll make a decision about it. But my concern is that the customers of this company are going to get a fairly nasty surprise, and I view them as, I guess, not a responsible party in this sense. I mean, they're customers of the company, but it's not their fault that we're in this situation. So I'm trying to figure out a way to ameliorate the rate impact on them, but understanding that, there are fundamental financial issues with this company that need to be addressed. So with that, I guess I'll turn it over. I'll start with the water company. Why don't you take the first crack at this, and then we'll go to OPC and then staff.
Yeah, good morning, Mr. Chairman, and good morning, commissioners. The water companies have been at this process for quite a long time. I got involved in fall of 2023, but that came several years after there had been ongoing discussions between Mr. Crooks and staff about a potential rate increase. My understanding is those discussions kicked off in the 2017 timeframe after many years of the water companies not filing for increase. So beginning in fall 2023, we began discussions in earnest, because this is a staff-assisted rate case. These are all small water companies. Began discussions in earnest about what the proper level of operating expenses is, what the level of capital has, immediate capital investments needed to be made, and then also looking at some of the federal environmental obligations with which the water companies need to comply. In determining a revenue requirement and cost of service model, we went through that process for many months, including with OPC's expert witnesses, with Mr. Valcarengi, and eventually reached an agreement on what the appropriate revenue requirement is. The phase-in under the settlement was designed specifically to stop the hemorrhaging on the cash operating losses in year one of the settlement. And keep in mind that adopt 2020 last year, water companies' actual expenses continue to increase as a consequence of inflation. From the 21 year was specifically calibrated, as Mr. Valcarengi testified at the hearing in December, specifically calibrated to make sure that revenue equaled actual operating expenses. And then the subsequent year two phase in of that increase was to bring revenue up to the allowed level of return that was agreed to in the settlement. The fact that the water companies didn't file for a rate increase for many, many years, I wasn't privy to that. Mr. Crooks perhaps can speak to that, but for the purposes of trying to ensure the continued financial viability of the water companies, that year one rate increase under the settlement is necessary to make sure revenues get at least to a level of 2021 operating expenses. So when we think about phase-in alternatives, we could perhaps put that aside, but then you're threatening the continued financial viability of the water companies. So this flexibility, how we proceed, is extremely limited. I think all parties continue to stand by this. We did that in the hearing process. And after we saw the judge's decision was 4-year phase in, we knew that for 3 of those 4 years, revenue was not operating. I did take any questions of staff, and OPC have been at this as well.
Okay, so any specific questions for the water companies? For any of the commissioners? I actually can't see everybody, so if you got a question, you might want to just go ahead and ask it.
I have no questions.
Fine. Okay.
I don't have any questions either.
Actually, a little hard to hear you, Kumar, so it might be the picture thing. So
You know,
yeah, I can't really hear you at all. So that's you mean?
oh,
Well, actually, go ahead and say something right now, because I just heard you the last time. You can't.
I don't have any questions.
Okay, so now I hear you well. So you're good. All right, so let me now turn to OPC.
Good morning again. When OPC got involved in this case, several years after the staff and the company started working together, it was immediately clear to us that the circumstances of this case were quite unique. Every rate case involves some sort of balancing of the money that a utility needs in order to provide safe and reliable service with the impact to customers' rates. But this case presented facts all its own. The water companies had not had rate treatment in some cases decades and were operating under significant cost increases and new regulatory requirements. Also, each water company has an incredibly small number of customers, all of which are residential and all pay flat rates without any metered volumetric component to those rates. OPC's overarching goal, as always, was to make sure that the new rates reflected the updated actual cost of service while ensuring that ratepayers did not pay more than they have to. For us, that meant working out an agreement that avoided carrying costs. As staff's recent filing from Mr. Valcarengi shows, carrying costs mean that ratepayers end up paying significantly higher rates in the long term. And that's something we wanted to avoid. At the same time, OPC had to be comfortable that the companies received enough money in the first phase of the phase-in to provide safe and reliable service. OPC believed that the settlement agreement rates struck that balance. Admittedly, looking at the percentages, the rate increase resulting from the settlement is quite high, but percentages only take you so far. In this situation, it is also appropriate to consider the dollar increases. Ultimately, as I said, OPC believed the settlement agreement resulted in just and reasonable rates and allowed the company to provide safe and reliable service with the cash flow that it provided the companies.
Okay. Any questions for OPC?
I do, Mr. Chairman.
All right.
So,
Actually, Bonnie, go ahead. So,
Okay. Well, do you want me to wait or?
no, go ahead. Ask your questions. So,
Okay.
you go.
Okay. So, Mr. Miller, hearing what the chair had said earlier about the fact that regardless of what residential ratepayers were paying, they're accustomed to a certain amount, even if it doesn't reflect the cost of providing water to them. In your negotiations, did you think about a way to lessen the impact over a couple of years? I mean, I understand the concern about the 4-year period that doesn't reflect carrying charges, and that's going to have a big impact on the water company. But was there any conversation about ways to ameliorate the impact for those 2-year period when the rates that customers are paying are going to go up substantially?
Sure. So, Commissioner Suchman, we did look at various options to phase it in at different, lengths of time and include different amounts each time. And there's probably, an infinite number of ways to do it. But the carrying costs were always a sticking point for OPC. We didn't want the customers to end up paying more in the long term. And from our understanding and negotiations with the company was only able to forego so much income without getting those carrying costs back on the back end.
Okay.
So we did discuss, but we had from our side the not wanting customers to pay more long term than they had to, like taking out a loan essentially from the company with the carrying costs, and the company having enough to function.
Okay, but you did look at sort of maybe 2 years, 3 years, 4 years, and so the 2 years was sort of the balancing of different concerns.
That's correct, John.
Okay, thank you.
Okay. All right. So let me turn to staff. And I guess one thing I'd like to understand is staff's interaction. I know some of this predates when you arrived, but get an understanding of staff's interactions with the water companies and sort of what they were told when, as far as how to proceed in this process. So.
Chair Hoover and Commissioners, I believe Dave Valcarengi would be the best person to speak to that.
Okay.
Let me start by saying the rates in place for Mr. Crooks's companies have all been in place since before the year 2000. And he hasn't sought, and the rates haven't been examined during that period of time. Mr. Crooks approached staff in, I want to say, roughly July of 17. And then Mr. Crooks determined that he needed to do a bit more capital improvements. And so it went into a stall phase, and it picked up again about, I want to say, 1.5 years, 2 years later. By that time, we were in the midst of BG&E's first multi-year rate plan and having to deal with the multitude of how to deal with a new form of regulation. We got inundated with that model and this model. But ultimately, I think when you look at the ending result of what came out of the negotiated rates in comparison to what the rates are in the settlement. You're comparing them to rates that were put in place back in 92, 93, 95, in that time frame. And I want to say the full rates, they range from 291 per quarter, and that's for Paul Monk. If you put that on a monthly basis, that's $97 a month. Currently, some of the customers are paying significantly below that. I want to say $20 per month. There's a $60 per quarter. You divide that by 3, you get $20 per quarter. I think that the 2-year phase-in plan that we ended up negotiating and arriving at in terms of the final rates provides Mr. Crooks's companies a sufficient level of revenue, averts his financial crisis, and allows the customers to be comfortable with the rates that are coming. And it totally moves away from phasing in and having customers pay a large pocket of dollars for deferring the revenue collections over an extended period. But also keep in mind that we specifically set up the rates in the settlement such that under the 2-year plan, Mr. Crooks would essentially be cash positive coming out of year 1 and going into year 2. And that was important for us because having a company that is in dire financial condition doesn't do anybody any good. And let me just point out, the test year that we looked at was 2021. And so for the 10-year period ended 2021, all of the companies have produced in excess of $2 million of operating losses, which is to say it's not something that is sustainable. Something needs to be done quite quickly. If you implement a result that extends it over a period of years, while Mr. Crooks will be whole in the interim, he lacks the financial cash in the initial periods, which is a problem. I think as the paperwork that I submitted indicated that the 3-year plan resulted in customers paying an additional $227,000, and the 4-year plan ended up $373,000. So under the 2-year negotiated rates that the parties developed, Mr. Crooks is voluntarily relinquishing approximately $100,000 that he ordinarily would have been entitled to. And I think that's key in the competing interest, how to stabilize Mr. Crooks's companies and how to properly put in a rate that allows Mr. Crooks to do what he needs to do, but recognizing the significant rate impact. I think when you compare the final rates from the settlement are in the range of $70 to $90 a month. And in comparison, the monthly rates that are currently in place range from, they're in the neighborhood of $20 to $14 a month, which in my opinion are abysmally low. And it harkens why Mr. Crooks is feeling a financial pinch. And bear in mind, this is all based on 2021 data. It doesn't even recognize 2022, 2023, 2024. So this just puts Mr. Crooks on a stable platform, but 3 years ago. So we know additional rate relief is going to be needed. Is it going to be tomorrow? Is it going to be next year? This just puts Mr. Crooks in a stable position based on the data that we have as of the end of 2021. And I think it does it in a responsible manner that doesn't overly charge ratepayers significant dollars.
Okay, any questions for Mr. Valcaringi? Bonnie, go ahead.
Yes. Is it possible for you, because I don't think I don't feel like I have sufficient data to actually kind of look to see what alternatives there are. I understand that Mr. Crooks had negotiated away the carrying charges for that 2-year period. If we were to allow carrying charges, but require that there be a phase in over, like, for example, a 4-year period, is there a way to calculate what those costs would be for ratepayers? I understand your concern that ratepayers are now significantly underpaying, but they don't know that. So if they've got a $20 bill, they may not necessarily know, wow, this is really a great deal. I would really like to keep paying $20. All they're going to know is if they get a subsequent bill of $40 or $50, it's going to feel like a big jump in terms of what their responsibility is. And so it would be helpful for me if we can have sort of some alternatives about what the numbers look like over a period of 4 years, because even with carrying additional carrying charges, it may actually just be more palatable for ratepayers if there's a more gradual increase in their water bills.
Well, certainly a phase-in plan can be calculated any number of ways. I chose to just streamline the rates. In the case of the 3-year plan, I did 1/3, 2/3, and then whole in year 3, and then I implemented a surcharge beginning in the following period that would run for a period of 3 years.
Okay, have we seen that? I haven't seen that. The 3
I
years.
filed that. I filed those plans yesterday or Tuesday, and then Wednesday I made a correction to the impact of the rates under a 4-year phase-in plan. And I think the problem with phasing it in, ultimately at the end of the phase-in plan, Mr. Crooks would be presumably whole financially, but the problem is if you don't implement rates that put Ed on a financial to cure his well-being, the financial ails, he's going to continue to bleed. And that's what the problem is. The rates from the settlement provide him a pathway forward that he can go and operate as a business.
Yeah, so Mr. Valcaringi, there's no question that the rates are wrong. The question is, and this is again going back to the chair's initial comments, how can we find a path forward that doesn't result in a huge bump up in the bill pretty early on in the process? So that's so it's just is there a path forward that would allow for a smoother transition to where the rates should be?
The short answer would be no.
I don't like those responses.
Well, I'm trying to be upfront and honest.
Yeah, no, I appreciate it. Thank you.
We appreciate that. So
the problem is what I call the current rates or the going in rates are exceptionally low. In order to put Ed on a stable platform, the revenues have to go up in order to provide Mr. Crooks, sufficient revenue so that the company isn't experiencing operating losses.
Okay.
Now, certainly, if you took the first year rates from the negotiated settlement and then work on 2 or 3, the idea is you need to the rates from the settlement, at least in year 1, were designed to be cash positive for him. And so that's why he was willing to leave $100,000 on the table as a means of, he knew he was going to be cash positive through the process. If you're setting up rates that have inclining rates over a period of time, it doesn't provide him cash flow. He's going to be at a negative, and we're going to be doing this again tomorrow.
Okay. So, can you also explain whether the settlement year 1 rates cover both rate base and O&M without a return?
It recovers expenses of the operation, the capital improvements that Mr. Crooks has made, plus a return at a rate of, I think it was 7.26%.
Okay, so it includes the return, but not the carrying costs.
It does, the negotiated rates from the settlement in no way reflect carrying charges.
Okay. Okay.
And let me add that the return on doesn't occur until the second year of the phase in. So I think the key takeaway here is that the revenues in year 1 were calibrated to match 2021 actual operating expenses.
Okay,
And
so only O&M, but not a return.
Correct.
For
No
year
return on in year 1.
Okay.
So if we're talking about a phase in, I guess there is a small amount of the rate increase that occurs in year 2. And that represents just the minimal amount of return on the capital investment.
Okay.
So the options, a phase in would
Actually,
maybe to work that small, but if rates under the settlement, then companies will have an operating loss.
Okay.
so
Just-
actually, we're having a little. Let me just do one technical thing. So we're having a little problem hearing you because you're starting to break up. And my understanding from the IT folks is that if you turn your camera off, it actually helps the sound. So as much as we'd love to see you, it might actually work better for us to hear you if you turn the camera off. Okay.
Okay, let's give
Go
that
ahead.
a shot.
Okay, so Mr. White.
Yeah, that actually that sounds great. So thank you
Yeah,
very
so-
much.
Just to be clear, so year 1 settlement, no return. Year 2 is a smaller return, and then when we get to year 3, that's when you're seeing the full return on rate base.
No,
Under the
no.
settlement, Commissioner, there are just 2 years of phase in. Year 1 is to try to bring, or it does bring, revenue up to 2021 level operating expenses.
Okay.
And then
Okay,
the
and then
second,
so then
second year,
Go ahead.
the second year of the phase in adds the return on, so that at the end of year 2, the actual revenue equals the revenue requirement using a 2021 test year.
Okay. So
That's
year
the
1,
intent.
full O&M, year 2, O&M, and then return rate base.
Correct. And
Yes, that's right.
0 carrying charges in there. The company per the settlement, agreed to essentially a $99,000 reduction to what it otherwise would be entitled on a full revenue requirement basis in order to reach the settlement.
Okay, thank you.
Mr. Chairman?
Yeah, go ahead, Commissioner Barve.
Okay, I have a question for Dave. Let's just think theoretically about a 4-year phase out. Obviously, that's going to be detrimental to Mr. Crooks and his business. But if we were to spread it out over 4 years, and then there was a sudden increase in interest rates in the economy, obviously, Mr. Crooks, though he's not asking the ratepayers to pay for the carrying charges, he's assuming those costs himself. If there were a sudden increase in interest rates 2 years from now, or 3 years from now, or 4 years from now, that would be pretty detrimental to his economic condition, wouldn't it?
Well, it's not only going to be detrimental to Mr. Crooks, the phase-in plan. I sent you calculations for a 3 and 4 year phase-in plans with carrying charges, and under both of those scenarios, they result in customers paying significantly more than what customers would pay under the negotiated rates from the settlement.
Well, the point I'm trying to make here, or the question that I'm trying to, are you able to hear me?
Actually,
Yeah,
you're breaking up.
you're going in
So
and
you might
out.
want to turn off the camera. No offense to
Yeah.
great looks. So.
Okay, I turned off my video.
Okay.
I hope you can hear me now. Okay, so what I'm trying to tease out here.
Better, so go ahead.
Okay, Dave, what I'm trying to tease out here is that if we were to extend the settlement to 3 or 4 years, and there was an unanticipated spike in the interest rates between now and then, that would be very detrimental. I guess the point I'm making here is that if we were to stay with the original settlement, we have less of a concern about unanticipated interest rate increases than if we spread it out. Am I basically correct there?
Well, forward interest rates won't have an impact on the collections. Under the plan that I developed, it would be a fixed monthly bill that customers would pay, and it would lapse off after the end of either a 3-year period or a 4-year period. Now, certainly interest rates on a forward-looking basis will impact Mr. Crook's ability to finance his operations. It may have impacts, but it will not impact the collection of this revenue requirement that we have here.
Well, the reason, and thank you, Dave. I expected that as the answer. I guess what I'm trying to tease out here, I'm trying to put myself in the shoes not only of the ratepayers but also of the company, because I think Mr. Crooks has been holding off raising rates for a very long time, and I think that's noteworthy and positive. I hate putting his company in a position where he is unduly stressed, because given how narrow his margins are, I'm concerned about what the long-term effects to the ratepayers would be if we don't fix this problem sooner rather than later. You see where I'm going?
Yeah, if you don't fix the problems, and by that I mean attempt to remedy the cash flow problems that the companies are experiencing, then the problems are going to multiply. And who knows if Mr. Crooks is going to have the ability to continue essentially shouldering huge losses.
And that would be a problem for the ratepayers.
That would be a significant problem.
Okay, thank you. You've answered my questions. Thanks a lot, Dave.
Commissioner Sussman, you got?
Yeah, just a very quick follow-up to Commissioner Barve. So if we were to include carrying costs at some point in this settlement, do we run the risk of higher cost to ratepayers because interest rates have gone up? I think that's where Commissioner Barve was going, or at least that's
Yeah.
what I heard from that.
The phase-in plan calculations that I provided both on Tuesday and yesterday, I used the rate of return embedded in the revenue requirement, 7.26%. So should the markets change over the course of the next month, years, whatever, that's not going to change or impact the revenue collections that are embedded here.
Even if we allow, let's say, for example, we require a 4-year recovery, but we're allowing Mr. Crooks to recover carrying costs.
But the problem with a 3-year or a 4-year plan that I developed, they, at the end of the road, they make Mr. Crooks whole. But the problem that you would run into is the financial pain that he's going to experience.
No, I understand all of that. I'm really just focused on Mr. Crooks has agreed to waive carrying costs.
Yes.
For this 2-year cost recovery. If we were to allow him recovery of carrying costs and we take the settlement out for 4 years, do we expose ratepayers to the possibility of having higher carrying costs because interest rates have gone up?
Yes.
Well, yes, well,
Because Kumar, that's where you were going, correct?
Well, let me explain where I was going with this. You know, obviously the 2-year settlement basically solves the problem in 2 years, regardless of what anything else you say. Ordinarily, but we're in weird economic times now, and who knows what decisions are going to be made downtown in DC and what effects that's going to have on interest. And my overall concern is that if we spread this out too long, we could put Mr. Crooks's company in a position where they will have to ask for yet another rate increase 3 years later down the road, or immediately after the phase in, and he and his companies will be in just as bad a situation as they are right now, maybe even worse because of the time lag. So that's really that's my concern. I think we have economic variables that are dangerous in this economy. Whereas, you know, the quicker we solve the problem, I think, the more we minimize the possibility of these variables intervening and causing mayhem for this company. That's where I was going.
Right. And I understand that, but I guess I want to try to follow up on Bonnie's question. I mean, if we did add back his contribution that he made, but we spread it out over a longer period of time, I mean, is that a viable path to putting this together? Because I guess one of the concerns that I have is, you know, trust me, we've been getting tons and tons of fan mail from customers of gas and electric companies about the impact of the higher rates on them. And that's obviously a lot of different things are involved in that, you know, between Mother Nature, PJM, and stuff we've done. But one of the problems has been with utility service is you don't see the bill until after you've used the service. And so one of my concerns is, you know, if the rates increase significantly and people aren't really aware of that and they're sort of using, you know, whatever amount of water they use, and then they get this in the mail the next month, you know, they're going to be in difficult straits trying to pay the bill. I mean, that's what I hear, all these letters I get from the gas and electric company customers saying, hey, you know, I use this amount of electricity or natural gas in January because it was cold, but I didn't realize that the price of the product had gone up significantly until I get this bill. So we're trying to figure out a way, as Kumar said, you know, people are very sensitized now to cost of living expenses, and you know, water and utility services are prime factors in that.
One of the things to keep in mind is that the rates are fixed. They're not, whether a customer uses 10,000 gallons or 1,000,000 gallons, they pay whatever the tariff rate is. So it's not a volumetric consumption. So it's not going to be Mr. Homeowner pays $45 times 3, and now he's paying $900 a month. He'll pay the negotiated under the settlement in year 1. The customer would pay $55 a month, and then in the second year, they would pay $70 a month for this one particular company, Calvert Beach. So it's not volumetric. We hope to move to volumetric to some of the companies in the future, but these are all fixed fee bills.
Okay, so well, that actually might be helpful. So you're telling me if I use 10 gallons or 1,000 gallons, I'm still going to pay the same
rate.
price. Okay.
Yep.
But obviously the problem is it's going to be significantly higher than what I've been paying, but it won't be based on how much I use. So, all right.
Right, and I guess the point to stress is that the full rate will go at the end of the day for this one company ends up being $70. You compare that to what they're paying now, $20. I don't believe $20 for utility service is a reasonable rate to recover a sufficient pot of revenues in order to provide the company where they need to go.
No, I understand that, except, you know, if you're the current customer of the company, you don't know all this backstory information. You know, you just know that you were paying $20 a month and now you're paying $70 a month. And I'm sure the first question would be is, you know, why am I doing that? You know, and so, you know, I do think that whatever process we agree to, the company's going to need to do a fair amount of consumer education, and maybe they can work with OPC and staff in developing that to sort of give people a full understanding of here's why your bill has doubled, you know, or tripled, you know, in whatever case. So,
and I think that's a fair
Mr.
point.
Chairman, I'd like to speak to the notice to customers issue.
Okay.
So the public utility law judge went to great lengths in advance of the evidentiary hearing. We had 2 pre-hearing conferences. She required the company sent and submitted an affidavit indicating it sent direct mailers to the customers notifying them of the rate increases. This was back in September of last year, September of 2024. There were 2 public comment hearings, 2 public input hearings held. One was held virtually, one was held in person in the water company service territory. It did not, the number of customers who participated in the virtual hearings and in the public input hearing was a very, very small percentage of the total customers on the system. Mr. Crooks has heard from very few of the customers, even though all of the notices have been provided and out there for now over a 6-month period. And the rates were shared, the monthly rate before and the monthly rate after. So customers know what's coming. Most of the customers, I think it's fair to say, know they have been paying extremely low rates for water for a long, long time.
Well, I mean, I guess I wanted to challenge you a little bit on that, because I've been doing this for quite a while, and quite honestly, you know, as much free information that you send to folks, the reality doesn't really hit them until they open the envelope and it says pay X amount. And so I suspect that your customers, when they get the actual bill with the new rates, may have a whole different attitude about this than what, even though you've been trying to tell them, hey, this is coming, this is what's going to happen. The reality doesn't really hit until they actually open the pay this amount envelope. So I think we may need to do whatever we decide what the final amount is. I may want you to do another round of public communication on this. One other question, and this is for OPC. I mean, I don't necessarily, I realize you can't really talk about the negotiations you went through for the deal, but I guess what I'm trying to get an understanding of, was OPC comfortable with the sort of cost of service items that were proposed by the company and reflected by staff, or was there a wide variance of what the cost of service was?
This is Lafayette Morgan. I'll address that. We were comfortable with it. I guess for us there was one important thing that hasn't been mentioned, and it's that we did not find a ton of customer complaints in terms of the quality of service. And so when you look at what customers are receiving for the cost, it was, I would say, commendable that Mr. Crooks has been able to provide service, even though every one of the companies were incurring losses every year. So for us, going back and looking at the cost of service, we found that what we ended up with, even though it ended up being a significant increase, we still felt like, given the circumstances, this was perhaps the best deal that customers could get.
Okay, all right, I appreciate that. Any questions for Mr. Morgan from either Commissioner Sussman or Barbe?
Well, I actually had a question back to Mr. Valgarengi. So I'm still sort of thinking about the impact of increased interest rates on carrying costs and the exposure of residential customers if we were to have a settlement that includes carrying costs of sort, let's say, over a 4-year period. I mean, so we'll lock in those rates. I guess we can, so we won't allow Mr. Crooks to come in over that 4-year period, even if interest rates go crazy and he's losing money in, for example, years 3 and 4. But then he'll come back and we'll have a huge bump up in rates to reflect increases in carrying costs.
Well, he wouldn't be losing. If interest rates change on a forward basis, they're not going to change the recovery of what I call the deferred revenue items in the period over that extended period. The problem, as I see it, with the phase-in plan, unless you initiate a rate in year 1 or year 2 that gets Mr. Crooks close to being cash positive, then he's in a significant financial crisis.
Right, but we could do that if we allow for carrying costs to be reflected, I guess, in year 2. Or is it would we also need to reflect it in year 1? If we included carrying costs but extended it for a 4-year period.
The fundamental challenge here is that unless you provide flow in year 1 that equals just operating expenses, which is what the settlement does,
That's $55
companies-
dollars and 50
No,
cents.
now I sort of understand. So it doesn't really matter if
The
we were
companies
to,
will be cash negative.
right, if we were, even if we were to
That-
include
that's it.
carrying costs, if we don't get up to the O&M, you're gonna be.
That's right.
Okay, all
That's
right.
right.
No, okay.
And that, I guess that kind
Now,
of,
Mr. Chairman, I've got another question, Mr. Chairman, if that's okay.
Okay. Well, actually,
Yeah.
real quick, were you finished what you were going to say, Mr. Valcaringi?
well, I guess that what I was going to say was that demonstrates, I guess, the problem that the parties were dealing with. We
Yeah.
knew that Mr. Crooks was in a severe financial bind. And we knew that there was going to be a sizable increase. And so the question is, how do you do that palatably, provide a stable platform for Mr. Crooks while attempting to mitigate as best we can the rate increase that Mr. Crooks needs in order to operate the company and put him in a cash positive position. The way I look at it, the rates from the settlement do that.
Okay, Commissioner Barbe, go ahead.
Yeah, thank you. I have a question for either Mr. Crooks or his legal representative. If we were to go ahead with the original 2-year settlement, I know that you must have customers who are on fixed income. Do you have any plans to help them? Any kind of payment arrangements or forgiveness in the initial months? Tell me what arrangements you might make for people who are on fixed income and how you deal with that currently.
Bob?
I will defer to Mr. Crooks on that. Ed,
Okay,
are you able to speak to that?
of course. So, first off, let me point out to you that Calvert County and Charles County and St. Mary's County are among the wealthiest counties in the state. Their income is, Charles County and Calvert are within the second and third highest income of the state, off the top of my head. So that's one thing. The people who, and there is not an indigent population in the communities that I serve. It's not an indigent community. Are there people that live day to day? Perhaps they do. I get it. Everybody has their issue. But I also, pardon me? But I also know, and I know this to be true, every single household in every one of my communities has cable television. I know they do. Cable television is $250 a month in Charles County and Calvert County. I know they have electricity. Electricity in Calvert County and Charles County my electric bill is, and I don't live in it. I have a house without any occupancy. It's $300 a month. In the wintertime, it's more. If an individual comes to me and says, Mr. Crooks, or Ed, as I like to be called, thank you. If a customer comes to me and says, Ed, I have a problem. I can't do this. I will indeed make every opportunity to work out for him a weekly payment schedule instead of a monthly payment schedule, wherein it's not quite such a large amount at one time. I have a responsibility to all my other customers to not make sure that the cost of the utility is not spread equally among everybody. But I can make some allowances in the way that they want to pay it. If I can help them pay it, I will. If they come and say, I don't have it this month, but I'll have it next month, I'm not going to turn the water off. I don't do that to begin with very much. So if they say, hey, I'm a little short this month, I'll make it up next month, or I'll make it up over the next 3 months, I'm more than happy to do that. So,
Okay.
Pardon me?
No, I was just no, go ahead. I didn't mean to cut you off.
No. So as far as the affordability of what we have, what we're offering, again, I I have to stand by the fact that these are very wealthy counties. I have to stand by the fact I know these communities, and they are not indigent communities. They are not. I know that. Western Shores was at one time a weekend community for people who had place in DC and Virginia to come down on the weekend. There's still a large population of that going on there. Charles County has become a bedroom community for DC, and most of these people work downtown. So that I don't have a concern with. If somebody says, "Hey, I'm short," I can work with them. That's for sure. Ultimately, they will have to pay the bill. I believe that's only fair, but I can work it out to where they pay over 2 or 3 months. Spread it out.
Well-
That said, one of the things that's different for water than say energy, there aren't social programs like LIHEAP that a customer could apply to get payment assistance. It just doesn't exist for water utilities.
Yeah, actually, Mr. Valkerenji is correct about that. Although I think as a result of COVID, there was a short, brief LIHEAP-like program for water users. Mr. Crooks, I mean, I understand your conversation about demographics, but I think what you have to understand is we have a concern about all the customers, and you know, we've been going through proceedings with the gas and electric companies, making them to do various things regarding payment plans and restrictions on their ability to cut off service. And while I don't doubt your goodwill towards your customers, I can't just sort of leave it open-ended like that. So we may need in some final order to make some provision for notice to customers that if they're having difficulty paying with this, some process within your company is going to have to be established for them to contact you and certain things you need to do in response to it. I cannot just, you know, allow you to use your good judgment on customers in this situation. It's not part of the way we do the business.
I'm more than willing to discuss limitations.
Okay.
I'm more than willing to set parameters for cutting off the water. They already exist, as a matter of fact.
I understand. Okay. So let me get to next steps here.
So, Mr. Chair, just
go ahead.
one other sort of request or maybe suggestion, and perhaps there could be established, Mr. Crooks, some small fund or something that can allow you to sort of tap in. I mean, I trust your judgment that these are communities that can afford to pay this, but we always have to be mindful of those few customers that just don't have the resources. And so, you know, to kind of get them through over the first year or so of this kind of bump up, you know, maybe some limitations on disconnection of water. The problem with limiting disconnection is it's just going to mean that they're going to owe more the following month or the following 3 months. And so they end up being, for lack of a better term, they end up being significantly underwater. So if there's some sort of special fund, because we don't have those kind of resources someplace else, and it may never be used, but at least it's there just for that interim period, and then it can go away.
I'm more than happy to take a portion of the Public Service Commission's charge to me and set it aside for that purpose.
Okay, because that may be, and then after the 2-year
Commission
period,
charges me
it just
$250
kind of
a
goes
year.
away.
Public Service Commission charges me $250 a year for your needs. I'll be more than glad to take $50 of that, set it aside, and send you $200.
All right. Well, let's.
I mean,
hold off on
it underscores the cash flow issues we have. Where would such a fund come from?
I understand.
Touche, Mr. Crooks.
All right. Okay.
I was
So
going to bring that point up in that it is a noble idea to, I guess, create a reserve fund. The rates as developed don't reflect that.
right. I understand. So okay.
The only way it would have to be done would have to come out of Mr. Crooks's pocket.
Yeah. Okay. I understand all that. So
Mr. Chairman, if I may, this is Craig Cousin. I'm a CPA. I work very closely with water services and establishing the rates. I wanted to
Okay.
reiterate that the first year's adjusted rate is strictly the cash flow. It doesn't include any depreciation or cost recovery of any of the capital improvements. So it's
Okay.
strictly cash flow.
Okay,
So
I
whatever
understand.
he doesn't get on that, would theoretically, any shortage would have to come out of his pocket, assuming he would even have funds available to do it.
Okay. All right. So I take it there's really nothing to be gained by having an evidentiary hearing, because it sounds to me like everybody's sort of on the same page when it comes to what the pot of money needed is. And I just want to have everybody give me an answer to this. I mean, today, each of the parties still stands by the agreement that was presented to the Public Utility Law Judge, correct?
Yes.
For the water companies, yes, Your Honor.
OPC?
Yes, Your Honor.
Okay.
Staff's
So
fully
I
funded.
think, yeah, I understand. Okay, thank you. So I guess what I would like, and I realize you've already filed this once, I would like a filing from each of the parties explaining to us why you think the settlement that was proposed to the Public Utility Law Judge is the right result in this case, you know, based on sort of the discussion. And if you want to add to that questions that we've raised and discuss those issues, you're more than welcome to do it. I also would like, and this is an additional part to that settlement, I do want to have some provisions for extended notice or more extensive notice to the customers about what the impact of this agreement will be to them. And then some provision for customers who have difficulty in paying the bill for making notice to the company, and some thoughts about how that will be dealt with. And so, Mr. Crooks, I guess the message to you is I'm going to need you to sort of talk to OPC and staff and come to an understanding of what you're willing to do. And that's going to have to be essentially put in writing. So again, I don't question your motives, don't question your relations with your customers, but I think we're going to need something, formal as to what the process is going to be for those customers that feel they cannot pay the bill. So,
Mr. Chairman, let me ask a question about the
Sure.
additional notice to customers.
Mhm.
What would be, and the order that's established this hearing raised the issue of temporary rates. Every day we go by without new rates being put into effect is a day and another day of operating losses for the water companies. If you go through a process of issuing additional notice to customers, then what?
No.
So
What I'm
if
talking
five
about,
additional customers,
no. What I'm talking about is, should we, after we make a decision, either accepting this settlement or issuing an order doing something different, this is going to be information that you're going to provide customers of, this is what's coming. So it's not going to be delaying, your rate increase. You'll have your rate increase. I just want more notice to customers as to what exactly it's going to be. So other than having them open the bill.
Well, we have to do what the therapist created.
so
Yes.
we can the companies request that the new rates the settlement rates be put into effect immediately. The companies are happy, and when you look at the timing of that, if those new rates go into effect today, the bills aren't go out until mid-May, the end of May.
Mhm.
Companies are happy to send out a notice in the next few days to customers saying, these are the new rates that have been put into effect. Expect that the bills you receive in May will reflect that. We can do that, and we can do a direct mail to customers. We've done that in the past. We can remind them of what that level of rate increase would be.
May I say something, please? I have sitting on my desk right now a $10,000 bill to Pomunk, to Charles County Utilities for water. Pomunk doesn't have $10,000 to pay it. So the options are bankruptcy or I find the money. That's the reality of the situation.
Mr. Chairman, there's nothing to prevent the filing from coming in early next week. I mean, you know, it seems to me that if you're anxious to get moving on this, you know, I think we can rule on it as soon as it comes in. So this can come in relatively quickly and we can move relatively quickly.
Right. Yes. I think Commissioner Sussman's right. I mean, there doesn't seem to be a big dispute, you know, about, again, what the amount of money is. It's just figuring out how to get it collected. So
is this essentially, for lack of a better, a brief on why the parties believe the negotiated rates from the settlement are the most appropriate way to move forward?
yes.
Okay.
Yeah, that's it. So.
Right, but it's also responding to the chair's request that there be something in writing about the path forward for customers that are struggling to pay the new water bill.
So I think we have two issues here. One is, and I'm not clear on what the ask is in terms of a brief or something like that, given testimony that's already been filed by all the
I
parties.
understand it. So let me answer your question on that. So you did, as part of this process, you filed a document with the public utility law judge stating why you thought this settlement was in the public interest and met all the various requirements. I'm essentially telling you to do the same thing here. So if you want to copy and paste what you sent to the public utility law judge, be my guest. If you want to add to it and raise some of these issues that we've talked about today, be my guest. But I want something from each of the parties explaining why this is the only path forward.
So I'm a little.
Can we do that in a single filing? I mean, the parties, OPC staff and the water companies have been aligned since we reached agreement.
I understand.
Can
that.
we do that in a single filing?
Sure. If you want to do that, fine. Yeah. I mean, if you can get the other two to agree to that, or if you want to make 3 separate filings, we're fine with that too. So.
Well, actually, a single filing would make it clearer that the parties are aligned.
Sure. Yeah.
And then on the payment plan, we're happy to have this. Water companies are happy to have discussions with OPC and staff for the next couple of days,
right,
and figure out what a reasonable approach to a payment plan would be. But I'm just thinking off the top of my head, it would be for a customer to contact the companies, and then we would set up some type of guidelines on what the payment plan would look like. And if OPC has ideas about how to move that forward, I think we're open to that discussion, as long as the payment plan doesn't, we're talking about a payment deferral, but ultimate collection plan.
Yes, and I don't disagree with that, and I'm pretty sure that the folks at OPC can help you in doing that because they have lots of experience doing that with gas and electric companies. So these processes are not novel. So
just to be clear, with respect to the payment plan, is this it's a formal plan, but does it only impact the year one, or is it in perpetuity?
Well, I would think it actually might be a permanent situation.
So I guess, Mr. Crooks, are you comfortable with, I mean, I know that you sort of do these things on the phone, but are you comfortable with it just being in writing? I mean, it seems to reflect what you would do anyway.
I'm sorry, the agreement being in writing as far as the payment plan?
Right.
Right. Yeah. what the rules of the road would be with that. So,
Of course. Of
okay.
course I would.
Okay.
All right. That's fine. So, anything else? Oh, I guess I need to make it.
I just want to close the loop on,
Yeah, so let me, I
on,
think I
on
may
the customer notice. I'm sorry, go ahead, Mr. Chairman.
well, actually, you go ahead because I was thinking you were going to ask about something else, but go ahead and ask your question.
I was going to try to nail down the issue around customer notice
Uh-huh.
and the timing of when the rates would go into effect.
So,
Are the rates being put into effect today? Are you going to look at what's filed in the next day or two on that issue and rule pretty quickly to allow the rates to go into effect? We're happy to put out notice as soon as possible, but I need to know what to include in the notice.
So, Mr. Valcaringi, how's this usually work in the past?
Typically, the utility will put like a bill stuffer in the first bill after the commission essentially comes out with an order and says, you know, you can increase bills X% with these rates. It's difficult under these circumstances because the water companies don't know what rates are going to be implemented unless we use the temporary thing and they just implement today. And if the final rates that you approve are different, then we'll have to go back and reconcile. And
Right. Yeah.
that's,
Mhm.
but if it's your plan to have Mr. Crook send out a notice, then I think he would need to know what are the rates, what are the implementation dates and so forth, things like that. And whether they're temporary, permanent, whatever.
Okay, so why don't you, let's do this. This joint filing you're going to make, let's put the proposed notice to customers in that, and then we'll take a look at it and either approve it or change it. So, does that work?
And
So I
what
guess the next
effective
question,
date should we put in?
well, again, propose what effective date you want between the three of you, and then
Okay.
and then how soon can you put this filing together and get it to us?
I would say no later than Monday.
Yeah, I was going to say
Okay.
Monday, Tuesday.
Okay, well, that's fine. I guess.
I guess my question is, how does all that, ultimately it depends on how you rule. How does that play into the issue of temporary rates? And I guess that all depends on how you come out in your order.
I mean, I guess I don't understand your question.
By that I mean, if your instruction is, Mr. Crooks, you can implement the rates from the settlement, then there's no really issue in terms of temporary rates. If you implement something else, then I only bring up the temporary thing because it was in the commission's notice, and I guess I'm wondering, in terms of implementation, what instruction is he given to the customers? You're getting a bill of $50 this
Mr.
month.
Chairman, I don't think we need to address the temporary rate issue.
Okay.
Unless you're proposing a temporary rate. You as the parties.
I would prefer that the rates go into effect today or Monday or Tuesday as soon as possible.
Right.
Because every day is another day of loss.
Well, and I think I think temporary rates at this point would confuse the matter and delay the process. It seems to me.
So if you make the filing Monday, we will get an answer back to you that same week. So anything else before we? Okay, with that, we're adjourned. Thank you.
Thank you.
Thank you, commissioners. Thank you, Mr. Chairman.
Thank you.